Now we will begin today's webinar, Navigating Housing. My name is Madison McMahon Ward. I'm the program coordinator for Triage Cancer, and it's my pleasure to introduce our speaker, Steve Knox. Steve is a staff attorney with Triage Cancer. Prior to joining Triage Cancer, Steve worked with a nonprofit legal services agency in Detroit defending tenants in eviction proceedings. He performed community outreach to educate tenants about housing rights and trained and mentored students from several law schools. He brings to Triage Cancer an informed passion for providing empowerment through education to people in crisis. If you would like to read more about Steve, please visit the About Us section in our website. And remember, if you have any questions, please type them in the question box found in your Zoom toolbar, and Steve will answer them towards the end of the presentation. So with that, I'd like to turn it over to our speaker.
Thank you, Madison, and greetings, everyone. Here's our roadmap for today. We will discuss three main categories that people with cancer face as they address housing. We will talk about the laws that protect you from discrimination in all phases of housing, from searching for a new home to living in your current home. Next, people with cancer can sometimes benefit from changes to the physical setup of their home or changes to the rules about the housing where they live. So we will cover real-world strategies for modifying your home to make it more livable and suit your needs. And lastly, you may be grappling with the possible loss of your housing, so we'll help you understand the programs that may be able to help you stay in your current home and how you can access them. Where do we live, and how does a cancer diagnosis affect our housing? Well, about a third of us rent our home, while the other 2/3 of us own our home. This gap has been closing over the last 10 years as more and more people rent instead of buy their homes. And many people think that renting is less expensive than buying your home. But as it turns out, renter households and owner households spend about the same amount of money each month on their housing. Your home is critical to you and your family as you navigate treatment and beyond. You might need to fix it or change it or find a way to stay put or learn about what to do about housing discrimination. Where we live plays such a large role in our lives. Rarely can we let our guard down about housing. When those inevitable problems arise, understanding your options and processes is a good place to start. And terminology is important in the law, so we'll take a moment and define some of the words that we'll hear all the way through today's webinar. And when I talk about renters, I mean people who pay to live in a home that someone else owns. And renters are called tenants, and they rent houses, apartments, and condominiums. Now, condominiums or condos, they're like apartments, but the individual units can be sold. Then again, as it turns out, some apartments and condos are owned and not rented. But renters commonly have a lease from an owner, a landlord, or a property management company. And a lease is a contract to pay for a home for a period of time, like a year or month to month, and it doesn't even have to be written down. When renters fall behind on paying rent, they are at risk of eviction, a process that can end with the tenant and belongings removed from the home. In contrast, when I talk about homeowners, I mean people who own their home, whether they are finished paying for it or not. Homeowners also include those who live in manufactured housing, which used to be called mobile homes or trailers. Some special issues pop up here, and we will talk about those today. Now, when homeowners fall behind on paying for their home, which includes property taxes, they're at risk of foreclosure, a process where homeowners can lose the rights to their home and be evicted. Many people cannot afford to pay for a house up front, and they take out a mortgage. A mortgage is a type of loan you can use to refinance a home or buy it, and it usually has an interest rate, so you often end up paying more than you borrow at the beginning. Mortgages are also referred to as mortgage loans. You get your mortgage from a lender, like a bank or a credit union. Some mortgages are backed or guaranteed by the government through the Federal Housing Administration. So you hear terms like FHA backed or Freddie Mac and Fannie Mae. And these aren't people, actually, they're organizations that were created by Congress to help banks be able to give loans and to give some stability to the housing market. Some of these type loans have special programs that borrowers can access. Our first topic today is housing discrimination, what it looks like and what you can do about it. We'll provide answers to two questions. What laws protect me from discrimination based on my disability or status as a cancer survivor? And how do I use them? There are three main laws related to housing discrimination. We've got Section 504 of the Rehabilitation Act of 1973 and the Americans with Disabilities Act and the Federal Housing Act. Sorry, the Fair Housing Act. And one important federal agency to introduce here is the U.S. Department of Housing and Urban Development, or HUD. HUD has programs for people with disabilities and for people with low income. And maybe you've heard about subsidized rent, but how can you get it? It's good to know that these programs exist and can be extraordinarily helpful. Over 20% of assisted housing units contain a person with a disability. When you're looking, HUD is a good place to start and will link you to local subsidized housing providers. In many places, there's an overlap of government agencies and contracting companies that provide the various types of subsidized housing. Now, subsidized housing is a simple explanation. It means that the government pays for all or part of your housing. And there are a number of ways that this happens. There's privately owned subsidized housing, and these are usually apartments, and rent is lower than the market rate and often based on a percentage of your income, and sometimes can be as low as zero. Then there's public housing, and these are usually apartments, and they're for low-income families, the elderly, and persons with disabilities. These are run by the government, which could be HUD or a state agency or a municipal agency. And there's the Housing Choice Voucher Program, commonly called Section 8. And at a participating property, the voucher pays all or part of the rent. And those payments might come from the government or a contracting company. And then there's something called LIHTC. This is Low Income Housing Tax Credit Program. And here, the property has to set lower rent rates in exchange for tax credits. Rent is usually not based on your income, but only certain incomes will qualify in the first place. And with these, you have to watch out because they can end after a period of years. And a word of caution here, if you have to move quickly, even if you would qualify, the wait often will be too long to resolve your current need to relocate. There can be long waiting lists, narrow windows of time to even apply for a place on a waiting list, and there's sometimes technological barriers. The applications might be only online, or you might only get notifications about openings through email. Now, these are worth pursuing, but if you find yourself under pressure to move soon, look for regular housing at the same time to be safe. And if necessary, be prepared to secure regular housing for yourself first and then pursue a subsidized program. And if you end up living in federally assisted housing, which are programs that receive federal financial assistance, they have additional requirements for housing providers to avoid discrimination. But there are many types of these programs, and when you're trying to figure out if a place receives federal funding, it's not always clear by looking. You may have to research a bit, so look to HUD to identify whether your housing receives federal assistance. And some keywords are the ones we were just describing that you can look for: public housing, Section 8, LIHTC, or vouchers. They're all subject to Section 504 of the Rehabilitation Act of 1973, which we'll just call Section 504. Now, under Section 504, discrimination is prohibited on the basis of disability in federally assisted programs or activities. So related to housing, we see Section 504 protecting against discrimination when that housing receives federal funding. And it guarantees the rights of individuals with disabilities to participate in and have access to program benefits and services. Under Section 504, protected persons include people with disabilities and people associated with people with disabilities, like your family members and caregivers. I think Section 504 is a superstar. It paved the way for the ADA, and it's still widely used in the education setting. Now, under Section 504 in federally assisted housing, if you have a disability, here's what illegal discrimination can look like. You can't be denied the opportunity to participate in a program or activity because of your disability. And you can't be required to accept a different kind of program than what is provided to others without disabilities. And also, you may not be required to participate in separate programs from those available to persons without disabilities, even if those separate programs and services exist. For example, if your housing is a community pool with daily lessons for everyone and separate daily lessons for people with disabilities, well, that's a good thing. You have options. You cannot be prevented from going to either lesson, and you also can't be required to go to the lesson for people with disabilities. Now, the housing provider can't require people with disabilities to live only on the first floor or grouped into one area of the housing. They can't refuse to make you repairs or deny you access to common use facilities, parking privileges, cleaning services, or really anything that's made available to other residents without disabilities. And they cannot harass you or evict you or your guest. And you can't be denied the opportunity to serve on a planning or advisory board because of your disability. Basically, if a program or policy is available to other people, it has to be available to you too. Now, the ADA, the Americans with Disabilities Act, is a federal law that protects people with disabilities. You may have heard about it in the employment context, where it protects people at work. But the ADA also prohibits discrimination on the basis of disability in what's called places of public accommodation. Now, public accommodations are facilities that are used by the public. You might think that a building or development is private, but it might have portions that are public accommodations and therefore covered by the ADA. In the context of housing, this often comes up when a private place also has public accommodations. And any place that is newly built or newly modified has to be accessible to individuals with disabilities. For older places, any barriers to access that can be removed without difficulty have to be. For example, a private residential apartment complex might contain a rental office. The public can go into the rental office, so it is a place of public accommodation and covered by the ADA. And so is the pool or party room, if those are made available to the general public or by memberships to non-residents. And now we come to the Fair Housing Act, the FHA. It features prominently today in our discussion, and it touches every aspect of housing. The FHA is a federal law passed in 1968 that prohibits discrimination in the sale, renting, or financing of housing to people on the basis of race, religion, national origin, gender, and disability. Today, we will be focused on the protections for people with disabilities, but it can be useful to remember those other categories too. The Fair Housing Act covers most housing and most aspects of housing. It protects you from discrimination when you are renting or buying a home, or getting a mortgage, or seeking housing assistance, or engaging in just about any housing-related activities. And its protections are broad. It protects US citizens, permanent residents, or green card holders, people here on visas, and undocumented residents. Pretty much if you're here, you're protected by the FHA. Now, we just saw that the FHA is a very broad category for who is protected. And now we will look at another very broad category, who it applies to. Housing provider is the encompassing term we'll use for your landlord, apartment manager, or associations like homeowners associations or HOAs and condo associations. Those are the associations that set rules for your community, like paint colors and what your mailbox can look like. Housing providers can be individuals, corporations, property owners, co-ops, and really anyone involved in housing, lending, insurance, and real estate services. A housing provider can even be the government or a college. Now, generally, HUD, the Federal Department of Housing and Urban Development, has the resources and enforcement tools for the Fair Housing Act. Are you having housing issues or questions? Go to HUD. Do you need enforcement? That's HUD. Well, let's meet Chris. Chris owns his home in a development with an HOA, one of those homeowners associations. He is in active cancer treatment and he needs some medical care around the clock in his home. He finds a great in-home healthcare service and really likes the nurse that comes for the overnight shift. The nurse drives a company car that has the name of the agency on the side. But Chris's HOA has rules that do not allow vehicles with advertising wrap after normal work hours to park in the driveway or in the street. The HOA has sent Chris a letter warning him that he is in breach of the rules. So what can Chris do? Well, for starters, let's think about what we know already. It sure looks like Chris has a housing provider here, his HOA. And what we'll do is we'll check in later on Chris to see if we found something can help. Now, there are very limited circumstances when the FHA does not apply. It exempts owner-occupied buildings with no more than 4 units. That's when the owner lives in the building and there are 4 or fewer rental units. A good example is a duplex, when the owner of the whole structure lives in one unit and he rents the other one to you. And also exempt from the HRA, from the FHA, are single-family houses sold or rented without the use of an agent, and housing that's operated by religious organizations and private clubs when they limit occupancy to members. Now, every law we talk about has its own definitions. And here's how the FHA defines disability: as a physical or mental condition that substantially limits a major life activity. So you have a medical condition and it's impacting a major life activity, and that impact has to be substantial. It can't be something that happens once in a while. And then the FHA defines major life activities for us: activities that an average person can perform with little or no difficulty. Breathing, walking, talking, eating, all of these things are considered major life activities. To that list, we can add things like sleeping and concentrating and operation of major bodily functions, all things which are commonly substantially impacted by cancer treatment. Now, if you meet the FHA's definition of disability, because you currently have a disability, the protections apply to you. But the definition of disability also includes individuals with a history of having such a medical condition. And that's really useful for someone who isn't being substantially impacted by treatment anymore, but is maybe concerned about being treated differently because of a history of a cancer diagnosis. And the other way to qualify, by being regarded as having such a medical condition, really isn't about you at all. It's about someone else's perception of you. So your landlord or HOA is regarding you as having a disability, even though you might not be substantially impacted at all, and is treating you differently because they think that you have a disability. So what does the FHA give someone? Well, for one thing, protection from discrimination in housing, meaning that a housing provider cannot treat you differently because of your disability. All the members of your family, including your children, are protected from discrimination. Note that your caregivers are not protected by the FHA, but you may have rights related to those caregivers, as we will soon see. And if you currently have a disability or have a history of having a disability, you may also be entitled to additional tools that we will get to in a moment. Now, as I mentioned, the FHA applies in all phases of the housing process. When you are looking to rent or buy housing, you cannot be treated differently because of your disability. We do, for example, allow different treatment on the basis of income or credit rating or amount of your down payment. We will be focused here on the behavior of the housing provider and a list of things they cannot do if they are doing those things on the basis of disability. Now, recall those other categories, and those apply too, like race, religion, national origin, and gender. On those bases, when you're looking for housing, a housing provider cannot refuse to rent or sell housing, set different terms and conditions like different prices or rents, or different qualification criteria or applications. Like if there's a different application for a person with disabilities, and a housing provider can't provide different housing services or lie and tell you housing's not available to turn you away. And when it comes to mortgages, the FHA makes it illegal to discriminate against someone because of those categories, including disability, at any stage of the mortgage process. And this might be more than you think. The stages include approvals and denials, terms like interest rates and points, the advertising that they use, appraisals, which is where they determine how much your home is worth, help with a home loan modification, your homeowner's insurance, all types of housing loans. And lenders will commit discrimination when they refuse to make a mortgage loan or provide information about loans, or when they impose different terms or conditions on a mortgage loan, or steer you toward a bad product, or maybe provide inferior servicing of a mortgage loan. Okay, we're changing topics as we move from housing discrimination to address changes to your home. Now, following your cancer diagnosis, you may need to modify the physical environment of your home to change your space. There are two types of changes that you can make that affect your existing home. You can make a physical change to the property, like putting in grab bars in the shower or maybe wider doorways, or you can change a rule or a policy, like a closer parking space or paying your housing payment on the 15th of the month instead of the 1st. So if you live in a development with rules, like renting from a landlord, an apartment or a condo complex, or if you have an association, you might need a change in or exception to the rules. And of course, how to pay for those changes can be important too. So let's meet Andrea. Andrea is going through cancer treatment and she's experiencing chemo brain. She's been forgetting things and missing due dates. She tells the manager of her apartment complex that her mother will be paying her rent for this reason and asks if all notices relating to her rent can be sent to her mother so she doesn't miss a payment or a notice of a rental increase. The manager tells Andrea that the management company has a policy of only sending notices to residents, no exceptions. Now, what are Andrea's options? Well, like when we were talking about Chris, let's start with what we know so far. And also like Chris, it sure looks like she has a housing provider. Here we have an apartment manager. And do we think this property is exempt from the FHA? Well, probably not. We see an apartment complex here, not an owner living in the same building with less than 4 rental units. So let's see if we can learn about something helpful for Andrea and for Chris too. Now, reasonable accommodations are useful tools to ensure that people with disabilities have an equal opportunity to enjoy and use a dwelling. And full enjoyment means that you can have the same benefit from the place you live as people without disabilities. Let's break down what reasonable accommodations might look like and why they can be beneficial to you as you work through cancer treatment and beyond. For those with cancer-related fatigue or trouble walking, you might be helped by a parking space closer to your home or moving to a ground level unit or a unit closer to the elevator. And if you receive monthly income like SSI or SSDI payments, you can benefit from having your rent due after that payment arrives, like paying rent on the 5th instead of the 1st and not having a late fee. Now, some rental applications can only be submitted in person, but you might have a medical or treatment-related reason why you need to submit one online. You may even need a caregiver to stay overnight, despite restrictions in a lease about overnight guests. Remember, when I said caregivers are not a protected category under the FHA, well, they're not, but you may have a disability-related need for a caregiver, so you may be able to use the FHA to get a reasonable accommodation to have your caregiver. Let's go back to Andrea. What can she do? Well, she can ask for a reasonable accommodation. In housing, when talking about reasonable accommodation, it's about the rule or policy and how it applies to the individual. So this reasonable accommodation is a change in a rule or policy just for Andrea to have notices sent to her mother. And do you remember Chris, the homeowner who needs the home nurse? Well, he can do the same thing. He can ask his HOA for a reasonable accommodation, permitting his caregiver's vehicle with the advertising on it to park in his driveway outside of regular business hours. This would be an exception to a rule or policy just for Chris related to his disability because he needs that medical care. What's interesting here is that we see a homeowner, Chris, and a renter, Andrea, both requesting a reasonable accommodation from their housing providers. Now, where reasonable accommodations were about the changes to rules and policies, now let's talk physical changes. Remember, we are discussing those who need someone else's permission to make changes. There are 2 key questions to ask yourself. First, am I allowed to make the changes I need? And second, who pays for them? Making physical changes to your private living space or to the common areas is called a reasonable modification under the FHA. And they can include installing a ramp into a building. So this might be your space or the common area or even both. Lowering the entry threshold of a doorway, those annoying bumps that are between rooms. Putting in grab bars in a bathroom or a hallway, or maybe need wider doorways, or lower the sinks and the countertops. So think about what physical changes that are related to your disability that you need to better use your space. Do you need more than one reasonable modification? Well, someone might have more than one medical condition too. So now let's meet Donna, who's making her way through cancer treatment, but experiencing physical side effects. She has neuropathy, which impairs the use of her hands and causes her substantial difficulty in using the doorknobs in her apartment. Her building has dozens of units. She wishes to replace the doorknobs with levers, with handles. Donna asks for a reasonable modification, permitting her to change her doorknobs to handles. So here, can the housing provider refuse? Well, let's think it through a minute. Probably not. It seems reasonable. There's a relationship between Donna's disability and her requested modification. After all, Donna has difficulty with doorknobs, and it is connected to her neuropathy, and she's substantially impacted in walking. It's one of those major life activities. She needs to be able to open her doors in order to walk. And the modification is reasonable because handles are a helpful substitute for doorknobs. But who's going to pay to make this change? That's what we'll talk about now. Now, remember those reasonable accommodations. Those are the ones where you're asking to change rules and policies. Usually those do not have a cost, but even when they do, it's generally the housing provider that pays costs associated with those, not you. Modifications, though, those physical changes, can be another story. So you've asked for a reasonable modification, you've gotten it approved, now you'll likely have to pay the cost of any physical changes. In addition, the housing provider might require you to cover the cost of removing those changes when you move out. There's a caveat here. Providers may have to cover the cost if they receive government funding to provide housing. So the slide includes a website you can check to see if your housing is government funded. If you have to pay for it and you can't afford the modification, community resources might be available. For our healthcare professionals on this webinar today, these are a couple of great resources to send your patients to. 211 is a place to start for local agencies with resources. You can call 211 on your phone or visit them online. They're free, they're nationwide, and they're run by the United Way. And also in housing, you can contact a local or state fair housing center. Those operate in most states, sometimes with multiple locations. They're free and they exist to help renters and owners eliminate housing discrimination and ensure equal housing opportunities. Now, a housing provider may not deny a reasonable and necessary request. We keep using the word reasonable, and this is why. A provider is permitted to deny a request if the burden or cost to the provider is too high, or if it would be a major change to the provider's business. So think of something like there's a two-story apartment building with 6 units in it, and the housing provider is being asked to install an elevator. Now, that might end up being unreasonable. The cost here might be too much. Now, another reason is if there's other adequate choices available. Like, let's say you wanted to be closer to the laundry facilities, you asked to move to another unit that's closer, but instead, the provider installs laundry appliances right in your unit. Now, here's an example of being able to deny your request that you move to another unit because there is another adequate choice available here. And of course, your housing provider can deny your request if the property is not subject to the FHA, like when your landlord owns and lives in the home, if the home has less than 4 rental units. So a request for reasonable accommodation or modification sometimes can be verbal, but a request in writing can be helpful, so you can keep a copy for your records. The rules for where you live might require a written request, so check. Step 1 is yours, though, to ask. You may have to show how the proposed change is necessary and how it connects to your medical condition. Housing providers do not need to know the details of your diagnosis, only that you have a medical condition that qualifies you for protection and that it is related to your request. So your request should include a statement that you have a disability and how it affects the use of your home with the reasonable accommodation or modification that you need, and how that reasonable accommodation or modification will help you use the home. Now, you can get more than one, and you might need both accommodations and modifications. Remember Andrea, who needed the reasonable accommodation in the form of notices sent to her mother. Well, she might be forgetting to lock her doors, so she might need automated locks installed, and that's a physical change. And it might be a reasonable accommodation and a reasonable modification for Andrea to get both of the things she needs. And your needs can change over time, as your needs in active treatment might be different from your needs 6 months out or 5 years later. Your housing provider can change too. You should attempt to use the interactive process. You and your housing provider are supposed to discuss and try to find an agreement. So let's revisit Chris for a moment, who needs his overnight care nurse. Now, what if that HOA suggests that that particular caregiver vehicle be parked at the clubhouse? Well, if everyone agrees, then the interactive process worked. But if Chris does not agree, he does have some more options to pursue his reasonable accommodation, and we'll be getting into those. And remember Donna? She got her permission to change her doorknobs to handles, but who pays? Well, probably Donna, unless her housing provider agrees to help. Then again, does this provider receive federal funding? Well, we don't know. Donna should check because the housing provider might then have to pay for the modification. And what about when she moves out? Well, we're back to probably Donna again, if the housing provider has strict rules about apartment units looking the same. Reasonable modifications are about requiring the housing provider to permit physical changes, but not pay for them. As part of asking for reasonable accommodations or modifications, foremost on your mind may be disclosure. It's important to know that many laws protect your privacy, and the FHA does too. We're looking for the sweet spot here, enough disclosure about your disability to qualify for the reasonable accommodation or modification, but not too much unnecessary disclosure. After all, you may not feel comfortable sharing details of your diagnosis with your landlord. You might not have to disclose anything. For example, if someone uses a motorized scooter to move around and asks the housing provider to permit her to install a ramp at the entrance of the apartment building, that's both an obvious disability and an obvious need for a modification. The provider can see the scooter and therefore may not require any additional information about the disability or the need for the requested modification. Now, if the need for the accommodation or the modification is not obvious, then the provider can ask questions, but only for necessary disability-related information. They can't require you to disclose details about your diagnosis or severity of a disability or your medical records, and they can't ask you to take a medical examination. So remember Andrea? She may need to answer some questions from her landlord in order to get her accommodation. She does not have to say that she has cancer. She does not have to say she has chemo brain. She just needs to disclose that she has a medical condition that affects her memory and that sending notices to her mother will help. Now, if the housing provider still is not on board, she may need a note from her social worker stating that she has a medical condition that affects her memory. She should be clear with her medical professionals, though. She only needs verification that she has a medical condition that affects her memory. Assistance animals, these are a hot topic. Housing providers tend to be resistant and skeptical when the disability is not obvious or when you need an emotional support animal. And here is where HUD's guidance can help us understand our rights. HUD says the FHA covers assistance animals and that there are two types of assistance animals. There's service animals like a leader dog and other animals that perform in a support role. Now, service animals are dogs only, and they're trained to do work or perform tasks for an individual with a disability. Support animals are animals that do work, perform tasks, assist, or provide therapeutic emotional support for individuals with disabilities. But note that this is not only emotional support. To illustrate, one of HUD's examples of a support animal is a Capuchin monkey, trained to open a water bottle, insert a straw, and bring it to the person with the disability. This monkey, though quite talented, is not a service animal because it is not a dog. It is a support animal. But what's most important here is that service animals and support animals equal assistance animals. And when it comes to assistance animals, they're not pets. A housing provider may not charge fees or limit the size or breed. When your impairment is not obvious, the housing provider may ask questions about both the disability and the disability-related need for the animal. But an animal that does not qualify as an assistance animal, that is a pet for purposes of the FHA and may be treated as a pet under a lease and the housing provider's rules and policies. So a housing provider can exclude pets or charge a fee or a deposit, but not for assistance animals. So what can you do if your request is denied? First, you should try to talk with your housing provider to find an arrangement that works for you without imposing an undue burden on the provider. This is called the interactive process. You talk about it, you have a dialogue, you go back and forth to try to find agreement. But your provider might not engage in the interactive process with you, or frankly, might not be nice enough to work with. You still have options. If the interactive process didn't happen or didn't work, or if your housing provider said no and you believe that that no is wrong, you can file a complaint with HUD, either directly or with the help of a local fair housing center. Now, fair housing centers are a good first resource as they can provide more detailed information about your rights and your options. Both HUD and fair housing centers will try to assist with the interactive process. So even if you tried it on your own, here it comes again. When HUD or the Fair Housing Center gets involved, that's what they'll do. They'll try to help with the interactive process. And if an agreement can't be reached, then HUD might investigate. If HUD finds discrimination, they will enforce your reasonable accommodation or modification, either themselves or through another agency. And even if HUD looks and does not find discrimination under the Fair Housing Act, you may still be able to file your own private lawsuit. Overall, keep in mind, just because the law may not require that your housing provider grant you a reasonable accommodation or modification, well, that doesn't mean you shouldn't ask. To recap here, housing discrimination, there are 3 different laws protecting you and 1 place to report. You can file a complaint with HUD. They give you a number of ways. You can file online, by email, by phone, and even regular mail. And you can also access a fair housing center, and they can help you file a complaint. HUD may investigate and try to find a way for both sides to reach an agreement. And keep in mind that retaliation is illegal. Moving on now to paying for modifications. We'll talk about 2 categories here, those who own their homes and those who rent. For renters making physical changes, well, I'm not aware of any broad programs that can help pay, but start with your local foundations and nonprofits, and also cancer-related foundations. And think creatively. If you find financial help for utilities, for example, you might be able to apply the money you had set aside for utilities to your housing payment or to your modifications. Or the modification you need might also be an improvement to the property. Your bathroom remodel to improve accessibility may result in an increase to the value of the property, and your housing provider might be a willing partner and help you pay for it. Or perhaps you have Medicare Part B, and part of your solution is durable medical equipment, like a hospital bed, which Part B can help pay for. Now, for homeowners who are struggling to pay for needed modifications, you can look for grants and loans. Grants are usually money that is given to you and you do not have to pay back. But watch out, there's some grants out there that will switch on you if you move out, and then turning into loans that have to be repaid. And loans are just that, loans. You borrow the money, usually with an interest rate, and they do have to be paid back. You can look for low interest or forgivable loans. There are some forgivable loans where if you meet certain requirements over a certain period of time, you then don't have to pay them back. Loans can come from the government and the private sector, so you can look in both places. And your credit rating matters here, and Triage Cancer has resources. Our Adulting 101 webinar is both available at our website right now as a recording, and also will be presented again next month, so sign up. Now, grants can come from a variety of sources, and be open-minded here. You might not find a grant to directly pay for disability modifications, but you might get the funding you need from a home improvement or repair grant. Good resources here are HUD and the National Residential Improvement Association with their free search engine, and the federal government's specific programs, like for people in rural communities and veterans. Now, states, counties, and cities may have resources to fund your modification too. Look to your local housing agency, and HUD has offices in every state too, or even your area agency on aging. Also, private foundations and organizations have grants available, and some are specific to the disability or cancer community. If you can't find a grant to pay for the modification you need, you might consider a loan. Even though these loans we will talk about are not specifically disability related, they may be helpful to you to pay for modifications. And we have another FHA here. This is not the Fair Housing Act, that law we've been talking about, but now FHA stands for the Federal Housing Administration. This FHA backs some of the loans related to housing, like mortgages. And if you have an FHA-backed loan, and that includes Fannie Mae and Freddie Mac, There are specific loans that you may qualify for to make those modifications. They usually have a low interest rate, and some of them can simply be added on to your existing mortgage instead of creating a separate loan and payment. One of them is called the 203K loan, and this is a home renovation loan that just rolls renovation costs into your mortgage. And another option is a home equity line of credit, where you borrow against some of your equity. Be sure to shop around for a good rate, and it does not have to be from the same lender as your mortgage. Now, maybe your concern is not modifying your home, but about paying for the home itself. So now we switch gears to talk about ways to keep your home. We will cover strategies for staying put for homeowners and renters, the impacts on each of property tax foreclosure, and certain special issues regarding manufactured housing. Now, families that are behind on housing payments often are also behind in other areas such as utilities. So again, think in terms of your overall household budget, because if you find assistance in one area, that might free up money that can be used in another area. And again, the strategies we talk about today, not necessarily related to disability, they're general strategies and programs that might help anyone experiencing financial toxicity. And we know that individuals in cancer treatment and beyond may be working through financial toxicity. In a moment, we will look at those options for people that have FHA-backed loans. But first, here are some ways for all borrowers to avoid falling behind on your mortgage and avoid foreclosure. And there are some states that have funding available for mortgage and property tax payments, so you can check with the hardest hit fund. Regardless, communicate with your lender early in the process about any options you might have. Now, if you're negotiating with the lender and you can actually come to an agreement, there's some options here like refinancing or a loan modification. When you refinance, you replace your existing loan with a new one that has better terms. In a modification, your original lender changes the terms of the loan, the mortgage you already have, by extending the term or reducing your interest rate. Either way, it can be a pathway to a lower monthly payment. Or there's something called mortgage forbearance, which is an agreement between you and the lender to temporarily pause or lower your mortgage payments. Any missed payments must be repaid later, or you could end up in default and possibly face foreclosure. Now, a short sale is when you sell your home for less than the loan value, and then you ask the lender to forgive the difference. But here there may be tax ramifications. And there's also something called a deed in lieu of foreclosure. And this is where you sign over your house to the lender, and sometimes you get cash for keys, or you qualify for relocation assistance, or maybe even stay in the home now as a renter. If you can't reach agreement with your lender, you can always sell. But this is best for those with equity and the ability to rent somewhere or live with family until finances improve. Regardless, throughout all of this, watch out for scams. And at any time, you can talk to a HUD foreclosure counselor for free assistance. Now, do you have an FHA loan already? You're not sure who backs your loans? You can find out by using the website on the slide, available after today's presentation on the resource page. Now, this is a mortgage that is insured by the FHA and issued by an FHA-approved lender. These loans are designed for low to moderate income borrowers, and they require a lower minimum down payment and lower credit scores than many conventional loans. FHA borrowers may access special loss mitigation and loan modification programs. There are Freddie Mac, Fannie Mae, Freddie Mac, flex modifications. These are for conventional borrowers that have a Fannie Mae, Freddie Mac owned loan, and they can reduce monthly payments. There's also something called an FHA loan modification. For current FHA loan borrowers, it'll lower your interest rate, extend the loan term, or maybe add your past due amount to the loan balance. And for our veterans, there are VA loan modifications. These add your past due amount to the loan balance or extend the loan term. Now, some programs are impacted by federal efforts to address the coronavirus. The federal stimulus package, signed into law last month, contains some important deadlines for mortgage holders. There are certain mortgages that cannot be foreclosed until at least the end of January, and others cannot be foreclosed until at least the end of February. Fingers crossed, these deadlines might be extended. In addition, if you have not yet asked for forbearance, that's where you pause or reduce your payments. There are certain mortgages that have extended their deadlines for you to make that first request. And for those who have already have forbearance, you can request a 180-day extension. Information about these deadlines and ways to access this help are at the website on the slide. If you are 62 and over, you might have an additional option, a reverse mortgage. These are only available to homeowners who are 62 and over who have built equity in their home, meaning that your home is worth more than you owe on it. So you could sell your home and make some money off of it, but you want to stay and access that money to have your cake and eat it too. Well, you can. In a reverse mortgage, your equity becomes a loan. You are the borrower, but the payments are made to you all at once or spread out over time. In other words, your equity is paying you, but there can be pitfalls associated with reducing or eliminating your equity. Now, there are three types of reverse mortgages. There are single purpose. These are offered by some government entities and nonprofits and are for one purpose only, like paying property taxes or home repairs. Those with low and moderate income can generally qualify. And the other two types, the proprietary and the home equity conversion mortgages, they can be used for any purpose. They're better for those with a higher appraised value in the home, meaning your home is worth a lot, and you can qualify for more funds. Upfront costs can be high on these though. So there's some advantages to all three types of reverse mortgages and some issues to be aware of. Some of the pros are you get to keep the title to your home, and generally the money is not taxable. And you can use the money however you see fit, unless it was a single purpose reverse mortgage. Maybe you can use it to pay for modifications. You can choose to receive all the money at once or spread it out as monthly income. That equity was yours, you built it, and now you can use it without having to sell your home. On the flip side, reverse mortgages have pitfalls, so be informed and be wary. Note that this slide is longer than the pro slide. You have to stay in the home, and the loan comes due when you sell, move out, or die. Someone will have to repay the loan. Could be you, could be your spouse, your heirs, or your estate. And this might require selling the home, potentially dislodging anyone else who lived with you. If you have to move for health concerns or other reasons, the loan must be repaid. Moving into a care facility for more than 12 months is considered a permanent move. If your spouse was not part of the loan, then they may have to move out. Even if they can stay, your spouse won't be getting any more money from the reverse mortgage. Also, be aware that you use up your equity so you no longer have that safety net or the ability to leave it for someone else when you die. And reverse mortgages can have high fees and costs, and the interest gets added to the loan balance every month, so repaying at the end can be a lot more than the initial reverse mortgage amount. Many people take out reverse mortgages intending to use the ongoing payments to pay living expenses, but keep in mind you are still responsible for other regular payments like property taxes, insurance, and upkeep. If you fall behind on insurance premiums or property taxes, the lender can call the loan due, potentially resulting in loss of the home. And remember, reverse mortgages are only for people age 62 and older. Now, for renters, people who don't own their home, we also have some protections and programs when faced with financial challenges. A couple of good national places to look are the National Low Income Housing Coalition and HUD. Go to their websites for free searching for financial assistance programs. In your state and local areas, there are often community and social service programs like wraparound services, emergency assistance, and mediation. Look for those on 211, or you can search specifically the term homelessness prevention to find programs. Now, a notice from the landlord or a pending court case can sometimes qualify renters for financial assistance. Now, for all renters facing eviction, because you can't pay your rent or for any other reason, think about accessing legal advice and representation. There are legal rights hotlines and do-it-yourself websites funded by state bar associations. You can also look to area law school clinics. They might have a housing or eviction prevention clinic, and there might be law students there who can assist. Now, a lawyer is not required, but might be beneficial. When it comes to legal representation in the landlord-tenant world, there's a large power imbalance as the vast majority of landlords are represented and the vast majority of tenants are not. The federal government has some COVID-related renter protections. But don't be distracted by the word COVID here. You do not have to have COVID to qualify for the help. These new laws are COVID related because that was the reason the government acted. The latest stimulus bill signed into law last month contains money to the states to help renters that are struggling to pay rent. Now, qualified families will be able to use this assistance for past due rent or future rent payments, and even to pay utility and energy bills and prevent shutoffs. The money goes to each state, and then each state decides how to use it, so the programs will look different depending on where you live. Another COVID-related federal protection is the Centers for Disease Control's eviction moratorium. It was extended to January 31st, but it's not automatic. You have to take a specific action first by signing and submitting a document to your landlord to get the protection, and it only covers certain scenarios related to not paying rent. You can go to the CDC's website to learn how to qualify, make sure you qualify, and download the document you need. Now, rent is still due, you just can't be evicted while the moratorium lasts. And advocates are hopeful that the incoming administration will extend or improve the moratorium. Now, state and local governments have also acted to try to protect renters and avoid mass evictions. COVID-related state and local protections are a patchwork, and they can be confusing. One state might have dozens of different programs in different cities with different dates. So it'll be time to do some searching, and here's a guide. First, identify who is the actor. Who is issuing the protection for renters? Is it the governor, the state legislature, or your county or your city? Now, second, who goes first to access the eviction protection? Does the tenant have to sign and deliver a document, like in the CDC eviction protection? Or does the landlord have to prove that he or she sought assistance from a program first? Or does the landlord have to prove that the property is not covered by other certain COVID protection laws? Or maybe the protection is universal and no one has to act, such as when local court systems are completely closed and no evictions can proceed. Next, you look at what stages of the eviction process do the protections apply to. In some places, eviction court can proceed and end with an order to evict, but it's just that last order is paused. When this happens, when things resume, watch out because the eviction could be that same day. In other places, there are other phases of the eviction process that are stopped, like no notices can go out or no court cases can proceed, and these offer a lot more protection. And lastly, look at who qualifies as a covered renter. For example, in the CDC eviction moratorium, only a renter who is behind on rent payments qualifies. Any other type, such as when the landlord alleges a lease violation or the lease is expired, those are not covered. And in most places, there are certain tenant at fault evictions that can proceed. These are based on violence or drug activity or health hazard or damage to the property. And there are less savory landlords out there who are abusing this provision to try to proceed with evicting what should be protected tenants who are simply behind on rent. So we'll shift now and we'll talk about property tax foreclosure. Typically, people think of foreclosure as what happens if you don't pay your mortgage, but it can happen when you are too far behind on paying property taxes too. This disproportionately impacts seniors and people with low incomes who paid off their homes over a period of time, but now face new financial pressures, like what is all too common after a cancer diagnosis. For homeowners, property tax foreclosure can occur even when a mortgage is paid off, destroying decades of work and ending the opportunity to build intergenerational wealth. Property tax foreclosure occurs when the homeowner is delinquent in paying property taxes, and each locality has its own process. The entity who forecloses will be the state or local government, but is sometimes different from the entity that you pay your taxes to. For example, you might pay your property taxes to the city, but if you fall far enough behind, the county might be the one that forecloses. Now, in some areas, a foreclosure followed by an auction or an eviction is extremely rare, while in other areas it's all too common. So for homeowners in this situation, identify the process in your locality. Generally, there are two types. There's something called a tax lien foreclosure. That's when a lien is placed against the property and then that lien is sold. A lien is a right to take the property unless the debt is paid. Next, there might be a redemption period, and if not redeemed, there may be an auction or other sale where the lien holder acquires the property. And then there's something called a tax deed sale, has fewer steps. A lien is placed on the property itself. If it isn't redeemed, the property is sold at auction. So where are you in that process? The point is that there is a process. It has timelines along the way, and there's different interventions available. Seek financial or legal resources. Some states have specific funding to address delinquent property taxes. You can look at that hardest hit fund, and 211 is a good local resource. Now, surprise, for renters, you might have to know and care if your landlord is delinquent in paying property taxes, because you might not be aware that an ownership change or an auction of the property is someone new to deal with, or something that could lead to eviction could be coming. Again, there is process here with timelines and different remedies. The property tax status for a residential property is often publicly searchable. You can look online, or in some places you might have to go into a government office to check. Now, if a landlord is delinquent, determine that locality's process and identify the property's place in that process. Even if the property ends up taken, sold, or auctioned, tenants generally are entitled to some court process before they get evicted. So look for legal advice and assistance. Now, Triage Cancer's state resources link on the slide can take you to some do-it-yourself websites in your state and ways to find legal assistance. You won't be required to use an attorney, but remember that disparity. Most property owners have lawyers, most tenants do not. Now let's talk a minute about ways that you can own something, ways you can own property. There are two types of things you can own as property. There's personal property and there's real property. Personal property is something you own and it can be moved, you can transport it. Sometimes your home can be personal property if the home itself can be moved. Real property is something you own attached to the land that cannot be moved. This is the most common way to own a home as real property. We call these site-built homes because they are constructed on the site, on the land where they will stay. And site-built homes usually increase in value, and many people can purchase them with mortgages. But what if your home can be moved? Well, it might be what's called a manufactured homes. Now, these used to be called mobile homes or trailers, but those terms are sometimes seen as negative. Manufactured homes are built elsewhere, and they have a permanent chassis or a frame like a car does. So at least theoretically, they could be transported again, even if you don't see wheels. They are home to 17 million Americans, and there are benefits like lower construction costs, and they're transportable in a shorter construction time. Manufactured homes have their own unique way of being treated by building codes and by lenders. Often, manufactured homes are treated like cars, with less favorable loans than mortgages, with fewer financing options and higher interest rates, and they often have a lower resale value. Now, since manufactured homes are almost always classified as personal property, if you fall far enough behind, they can be repossessed like a car, and this process can be a lot faster than a mortgage foreclosure. Generally, when spouses own a home, it's what's called jointly. They own it together. And generally, one spouse cannot sell the home or add debt to the home without the consent of the other spouse. And if one spouse gets into debt, creditors usually can't take a home that is jointly held. So one spouse usually doesn't lose their home due to the other spouse's debt. But in some states, spouses cannot jointly own personal property, and then some of those protections may not exist. So there are situations when one spouse owns a manufactured home and can sell it out from under the other spouse or take out a loan against it. And then there's the separate problem of other debt, where a debt collector can take personal property, which might include a manufactured home. Now, some states will allow personal property to be held jointly, but others don't. And some states have a method for converting your manufactured home into real property. You'll have to seek legal advice in your state. And stay tuned to Triage Cancer. We have a new Congress already this month, and soon a new administration. We are likely to see a flurry of new proposals and new laws and new federal actions that affect housing. We will keep you updated through our blog posts. Now, whether you rent or buy, when facing the possible loss of your home, don't skip the stuff in the middle. By that, I mean, for example, eviction has steps to it. It's more than just one day you fall behind on rent and then your locks get changed. And foreclosure has steps too. It's more than you missed a few payments and then you go through a foreclosure. So think in terms of those steps. Identify where you are in the process. It can lead to your empowerment of what to do and where to find help. So thank you, everyone, and you can have Madison back now.